Imagine this, an entire lifetime of memories, decades of grinding it out. Literally every single dollar you've ever poured into your house, gone. Swallowed whole by a legal system that's secretly designed to drain your estate. And the crazy thing? It only happens if you miss 6 specific forms. But here's the really terrifying part. 90% of people will completely miss the 5th form on this list. In fact, they won't even know it exists until it's way too late, until their family is sitting completely helpless in a probate court, forced to watch a total stranger decide their financial fate. To understand exactly why this happens, we need to look at the brutal reality of the game we're actually playing. Listen to this. The American probate system was not built to protect you or your family. Period. It was literally designed to generate revenue for state courts and the attorneys who operate inside them. So every single year, hundreds of thousands of families are losing tens of thousands of dollars simply because nobody ever told them about these cheap or even completely free documents. Well, today, we're going to stop that from happening to you. All right, let's dive right in. Form number 1 is your very first shield. It's called the Transfer on Death Deed, or TOD. And this single piece of paper is a total game changer. It allows your house to bypass that entire messy probate process. Basically, the exact moment you pass away, the house instantly transfers to whoever you've named on this form. No courts, no lawyers, just done. And the contrast here is just devastating. Check this out. Without this form, the average probate case drains 3 to 7% of your estate's value. So if you've got a $300,000 home, your kids could pay up to 21 grand. And worse, it triggers 9 to 18 agonizing months where they literally can't sell it, they can't refinance it, but they still have to pay the mortgage. But with a TOD, $0 in court fees, instant transfer, total court bypass. And the best part is it usually only costs about $20 to $60 to file. Okay, moving on to form number 2, which is the Ladybird deed. Now, this is kind of like a secret form, and it's only available in 5 specific states: Florida, Texas, Michigan, Vermont, and West Virginia. So if you live in one of those states, you need to lean in and listen very closely right now, because this right here is an absolute, impenetrable shield against a massive government threat. And that threat? It's called Medicaid estate recovery. See, if you end up needing long-term care in your final years, the federal government actually has the legal right to force the sale of your house. Why? To repay every single dollar they spent on your care. To put that into perspective, a typical 3-year nursing home stay means the government can snatch $240,000 to $360,000 directly out of your estate. It completely wipes families out. But the Ladybird deed legally removes your home from your estate the absolute exact second you die, meaning it leaves absolutely nothing for the government to take. But, of course, there is a massive twist here. It's called the look-back rule. This awesome protection, it only works if you file the deed long before you actually need Medicaid. Because if you wait until you're already sick, this look-back rule cancels your protection completely. So that window to file, it's not closing tomorrow. It is closing right now. So you absolutely have to stay ahead of the system. Enter form number 3, the Revocable Living Trust. Honestly, this is probably the most powerful tool on our entire list. Now, yes, it does cost money to set up, usually between $500 and $3,000, but it completely changes the rules of the game. Because on paper, your house no longer belongs to you. It belongs to the trust. And that means it totally 100% bypasses probate, which can save your family up to $28,000 in fees alone. Think about it like this. A standard will just gets read in a courtroom, where a judge ultimately gets to decide your family's fate. But a trust? A trust is completely private. It bypasses the court entirely and executes your absolute specific instructions. Want to protect your house from a kid's messy divorce? Or maybe let a surviving spouse live there for life before passing it down to the next generation? A trust makes that happen, no questions asked. But then things get worse, because every year, thousands of people pay for a trust and still lose everything. Why? Because they make one fatal mistake. It's called funding the trust. They go out, they get the shiny new document, but they completely forget to actually update their home's deed to transfer the property into the trust's name. And guys, if you skip this step, that expensive trust is legally worthless. It is literally the equivalent of just burning your own paperwork. Now, even with a trust, you still need a safety net. So that brings us to form number 4, an updated will that includes specific state-level real estate language. If you skip this one, you fall straight into a trap that guarantees the state wins every single time. Here's what happens. If you die intestate, which just means dying without a will, the state government steps in and blindly divides your property based on completely arbitrary rules. Like in Texas, a surviving spouse might only get a third, while kids from a previous marriage get the rest. In California, community property gets totally slashed. Basically, the state assumes it knows best, and it ruthlessly divides your assets completely against your wishes. And this is exactly why your will absolutely must be reviewed every 5 years. Because I promise you, the state is always just waiting for you to slip up. Okay, before we finally reveal that ultimate fifth form we talked about earlier, we need to look at a silent drain that is happening to your money right now. We'll call this Form 6, the Homestead Exemption Filing. It is literally a free 15-minute application that can remove $50,000 to $100,000 from your tax assessment in many states.
And this is wild. Missing out on the homestead exemption, plus the additional senior exemptions that kick in at age 65, silently robs families of up to $60,000 over a 20-year retirement. And why does this happen? Just because nobody bothers to send you a warning letter. The government is quite literally hoping that you simply don't know to ask. But here is the massive catch. Every single document we just covered becomes completely useless if you fall into the trap that 90% of people miss. And it all comes down to one terrifying question. What happens when you can no longer sign your own name? Think about it. What happens if you have a stroke or develop dementia, and you just lose mental capacity suddenly? That is exactly where form number 5 comes in, the durable power of attorney for finances. This simple $100 to $300 document names someone you trust to handle your house and your money when you physically and mentally just cannot do it yourself. Without this specific form, your family faces complete, terrifying paralysis. They literally can't touch your bank accounts. They can't even pay your mortgage. And here is the absolute nightmare consequence of missing this. Your family will be forced to drag you through a grueling 6-month guardianship proceeding in court. We're talking up to $10,000 in legal fees alone. And during those agonizing months, nobody can legally pay the mortgage. Houses are lost to foreclosure every single year because of this exact, ridiculous waiting period. But listen to me. You cannot wait to file this. This document must be signed while you are mentally competent. The absolute second a doctor questions your capacity, the window closes permanently. You cannot sign it from a hospital bed. Once that moment passes, the only path left is the courtroom. And by then, the damage is already done.
So let's stop the bleeding right now. Here is your immediate 5-step checklist. 1. Find your deed. 2. Audit the forms you already have. 3. Search your state-specific rules. 4. Call a local estate attorney. And 5, act this week. Seriously, not next month, this week. Take this checklist and turn all that anxiety into immediate, empowering action.
You worked your entire life for that home. You probably raised a family there. A single piece of paper is literally the only thing standing between your children's inheritance and total loss. So as we wrap up this explainer, I'm going to leave you with this. Will you let the system take everything, or will you protect what you built?